Good morning, everyone. Thank you for joining us today. It's a pleasure to welcome you all on behalf of the European Network on Statelessness to this webinar on childhood statelessness in the UK and the upcoming Nationality and Borders Bill. My name is Andie Lambe, and I'm working with ENS on their Childhood Statelessness project. For those of you who are not familiar with ENS, we are a civil society alliance of over 170 organizations and individual experts working to address statelessness in 41 European countries. We do this through law and development and policy development, awareness raising and capacity building. This particular project, looking at childhood statelessness in the UK, is funded by the Paul Hamlyn Foundation and aims to better understand the causes of childhood statelessness in the UK, the children affected, the consequences for them and their families, and what action could be taken to help prevent and reduce statelessness, childhood statelessness in the UK. We're very excited to have you join us today, and please use the chat to introduce yourself, to say hello, and let and join in during the webinar. We've already got a number of people joining us, and of course there will probably be some people joining as we go along. And it looks like it's a good mix of civil society, some legal practitioners, and some parliamentary folks. So you're all very welcome. So a little bit of background. In July of this year, ENS published its research report on childhood statelessness in the UK. And for those of you who haven't read it yet, and I'm assuming obviously you've all read it cover to cover already, it is available on our website. And at some point during the presentation, we will post a link in the chat as well. But around the same time as publishing this report, the government also published the Nationality and Borders Bill. That bill covers a range of issues, but of specific concern to us is the proposed amendment at Clause 9, Part 1, to Schedule 2, Paragraph 3 of the 1981 British Nationality Act. This amendment does not reflect any of the challenges and hurdles that we identified in our research, and if passed, we believe will in fact make it harder for stateless children born in the UK who are under 18 to resolve their statelessness. So with this in mind, and with the bill heading to its House of Commons committee stage later this month, we thought it would be a good time to delve deeper into the report's findings, to hear directly from those affected by childhood statelessness and those who are working to reduce and minimise the impacts for children in the UK. Before I tell you a bit more about the programme for today, first, a quick bit of housekeeping. Jan, if you could do slide for the housekeeping, please. So just to keep you looped in, we are recording the session today, and this recording will then be made publicly available afterwards. The chat will not be visible in the recording, so feel free to say anything you like in the chat. It won't be shared, but also bear that in mind, it will not be shared. For all of you guys joining us, please make sure that your microphones and cameras have been switched off. And we have also enabled that function, so the only way you can talk to us at the moment is via the chat function. Feel free to use it. You can raise questions or comments, and my colleague Patricia is monitoring the chat and will respond to anything directly wherever possible, but also will be collating the questions for the question and answer session at the end of the event. And also, please do feel free to email us afterwards with any questions, comments, or feedback. So to briefly run through the agenda, our first speaker today will be Nina Murray, who will present on the main research findings and recommendations from our report. Nina will be followed by Sirazul Islam from the British Rohingya Association UK. And unfortunately, just to note that Sirazul has to leave us around 10:30. So if you do have any questions directly for him, please put them in the chat before he leaves, and then we can give him a chance to respond around 10:30. Sirazul will be followed by Andie, who is the Legal Director of Just Rights Scotland, and then Anita Hurrell of the Coram's Children's Legal Centre and Refugee and Migrants Children's Consortium will also speak. Then finally, Nina and I will give a brief outline of the next steps in terms of the parliamentary process of the bill and go into a bit more detail about what we think about the proposed amendment to the statelessness clause. Then it will be over to you for the question and answer, and we'll get to as many of those as we can with the time remaining. So you've obviously already heard too much from me. So I'm going to move swiftly on with the speakers and introduce you first to Nina Murray. Hi, Nina, welcome. So Nina is the head of policy and research at ENS. She joined ENS Secretariat in 2017 and has over 10 years experience undertaking and leading research, policy development and advocacy projects with a focus on statelessness, gender and refugee rights. Nina, over to you.
Thanks very much, Andie, and good morning, everyone. Thanks for joining us this morning. So as Andie said, we set out last year as ENS to, with our members in the UK and with the support of Paul Hamlin Foundation, to better understand the causes of childhood statelessness in the UK, which children are affected, the consequences for them and their families, and what action could be taken to help prevent and reduce childhood statelessness in the UK. So the first phase of the project explored this in more detail, so which groups of children and young people are at risk, why, and looked at the roots and main challenges they face to acquiring British citizenship, as well as making some recommendations, as I said, for change to address some of the issues identified. The project involved desk-based research, some literature review and consultation with a range of stakeholders with relevant expertise. And we also commissioned some case studies from ENS members who provide legal advice to stateless children and families, and reached out to other legal practitioners and community networks, importantly, for information from their experience as well. So to start with, which children? So we found that alongside children more commonly known to be affected by statelessness, because, for example, their parents belong to recognised refugee or migrant stateless groups such as Palestinians, Kurdish from Syria, Rohingya from Myanmar, Kuwaiti Bedouin. There are also other children or other groups of children in the UK who may be stateless or at risk of statelessness, but whose nationality issues are not so well known. So this includes some children in care, particularly but not always where they have a migrant background, because issues can arise when, for example, parental cooperation is required for a child to acquire nationality, but they're unavailable or don't cooperate, or when documentation proving family links is missing. We also found that some children of Roma families from European countries may be at risk, where, for example, parents entered the UK prior to their country joining the EU, and their resident status remains insecure, and they can no longer prove the links to their original country of nationality. And it was also indicated that other groups are potentially at risk, such as children affected by domestic abuse, trafficking, or other forms of exploitation, if they can't access proof of their identity or nationality. Then other causes of statelessness, childhood statelessness in the UK are explored in more detail in the report, but these include, for example, gaps or discrimination in nationality laws of parents' countries of origin. So, for example, gender discriminatory laws which prevent women from conferring their nationality to their children. And these exist in 25 countries around the world, and there's more information on this in the report. Or children being unable to register with parents, with the embassy or authorities of parents' countries of nationality, which can be required for the child to acquire nationality in many countries. And this could be because they are refugees, so they obviously can't approach their country, the embassy of their country of origin, because they lack the documentation to prove their links to that country, or because they face or fear discrimination. For example, in the case of Roma, they fear anti-Gypsyism on the part of the authorities, so are afraid to approach their authorities, or sometimes discrimination based on that rainbow families face, for example, so refusal by some authorities to recognise birth certificates where there are same-sex parents, or surrogacy arrangements, for example. So our report also sets out the legal routes to British citizenship for stateless children in the UK, and explores some of the key challenges that children and families face when trying to resolve their statelessness. So these include, for example, lack of awareness about what childhood statelessness is, includes, and this is particularly prevalent both among parents, but also among service providers, and a lack of knowledge about those available routes to citizenship. Children in state care were a particular group where lack of awareness of immigration and nationality matters created a risk of statelessness in some cases. And there was an uncertainty about referral routes to, or how to get support or advice to resolve nationality problems. Barriers to accessing legal advice were also emphasised by many stakeholders. So significant cuts to legal aid mean there are fewer providers of immigration and nationality advice, and families find it very difficult to access legal advice. And these problems seem to be worse in some parts of the UK than others. And early access to legal advice, we were told, can be really critical, and legal advice on nationality specifically, and can make a huge difference to children and families. And one of the stories that we heard and is included in our report is the story of Aisha, who was born in the UK to a stateless father and a mother from one of these countries where the nationality law of her country prohibits her as a woman from conferring her nationality. So because both of Aisha's parents, they weren't settled in the UK when she was born, means that Aisha was born stateless. And her parents took out a loan to pay the very high fee to register her as British, but they did this too soon. They did it before she was 5, so she wasn't yet eligible. So they lost that money, and then they couldn't find any legal advice, and they couldn't pay the fee again to reapply when Aisha turned 5 and became eligible. So that's just one example of the kind of barriers that children face. Other people we spoke to talked about difficulties proving nationality or statelessness. It's unclear what evidence is required, or families simply can't get hold of the documents needed. There are also significant barriers, as I mentioned before, to registering a child with the authorities of a parent's country of nationality. This can be due to complex procedures, lack of legal assistance, as I mentioned before, fear of approaching the authorities. Sometimes we found and heard that sometimes this could be overcome with considerable effort, but other times they were just insurmountable barriers that couldn't be overcome. And as highlighted with Aisha's story, one of the really key issues is the cost of registration. And the fee to register children as British is over £1,000 per child, and this is just simply unaffordable for families and caregivers, and can mean children remain stateless until or unless they can afford to pay that fee. So in response to these challenges and findings, we provide a few examples of good practice from other countries in the report for reference, and we also make a series of recommendations to the UK government, to the Home Office, to devolved administrations, to local authorities, lawyers and civil society, and all those working with children at risk or who are stateless. These include removing the fees for children's citizenship applications, improving access to free legal aid, not amending, very importantly, not amending the existing safeguard in British nationality law that allows stateless children to register as British, and we'll come on to that in a minute. Improving training and capacity of officials in the Home Office, of local authority caregivers, so they have the right information, and also for parents, providing better information to parents about citizenship matters. And also, of course, to work with communities affected to better understand and evidence these issues. So the relevance of this project and our report was really brought into focus when, as Andie said, when the UK government published its new plan for immigration in March, in which it alleged widespread abuse of the provision in British nationality law that allows children born stateless in the UK to, who've always been stateless, excuse me, to register as British from age 5, which protects them from growing up without a nationality. And this announcement in the new plan for immigration was shortly followed by the Nationality and Borders Bill, which I'm sure many of you are already familiar with, But in part 1 of the bill, this includes an amendment to the provision, which supposedly aims to prevent this alleged abuse. And I'm just coming to the end, Andie, I promise. So just to be very clear, in our report, we found no evidence of any abuse in our research, and the Home Office still has not provided any evidence of its own to back up its allegations of abuse. On the contrary, as you've seen, our research showed numerous barriers to stateless children acquiring British citizenship, even under the existing provision. Data on childhood statelessness is severely lacking. That was another one of our findings. And although there has been a slight increase in the numbers of children registering as British, stateless children registering as British between sort of 2016 and 2019, this data it's not disaggregated, there's discrepancies in the data, and really it's very unlikely to have been caused by any abuse, and it's more likely the result of increased awareness of statelessness, perhaps the introduction of new rules in the UK relating to statelessness determination in 2013 might have increased awareness on statelessness, or perhaps stemming from the great work of some of our members to raise awareness of the issue, or even of more stateless refugees arriving in the UK from countries like Syria with existing stateless populations and having children here. So we haven't seen any evidence of this so-called abuse. So we'll come on to this in a moment later on after we hear from our speakers, but all of this to say that the UK government's proposals is not addressing a real problem. And in fact, our report demonstrates that it could create new problems and exacerbate existing ones. So I'll stop there. Thank you, Andie.
Fabulous. Thanks so much, Nina. And hopefully that gives you, those who haven't sort of read the report, a good overview of our findings and recommendations. And as I say, Nina and I will be following on with sort of the impacts of the bill at the end of after our speakers. So next, it's a pleasure to introduce Sirazul Islam from the British Rohingya Community UK. Welcome, Sirazul. So Sirazul is a genocide survivor who was born in the Kutupalong camp in Bangladesh. He spent 18 years as a stateless person, but now reads law at the University of Manchester. And just to reiterate that unfortunately, Sirazul has to leave us in about 10-15 minutes. If you have any questions for him, please put them in the chat during his presentation, and if we have time, we'll get him to answer them before he leaves, and if not, we will send them to him afterwards and he'll respond directly to you. So let me just hand over to Sirazul. You're welcome.
Thank you, Andie, and thank you to ENS for doing this, because it's a much needed report into an issue that may have been overlooked quite a bit in the past, and it's an issue that people do not realize the generational impact it has and the ramifications of these issues, where statelessness and not having a nationality and not having a country has in the longer terms of senses for an individual and their family. As Andie introduced me, my name is Sirazul Islam, and I'm a Rohingya. I'm a British Rohingya now, and I was born in the refugee camps in Bangladesh, and I spent about a decade of my life there. And the things that I want to tell you today is the more humans it's an attempt to humanize this issue, because most of the time what happens is these reports come out, these parliamentary bills come out, but what people don't realize is the actual emotional impact, the actual work that goes on in the background of people who are stateless. As someone who has been stateless and as someone who has family that are still stateless, I'd want to tell you or assure you in the sense that this is not something we would wish upon someone, because what it does is it strips you of your basic dignities in life. For example, you don't have access to any basic human rights. These are people in refugee camps who have come from and fled genocide, who have fled refugee camps to seek sanctuary or to seek asylum in a country that they think would help them, and then they come to these host countries, but they face even more issues. And what usually happens is that these issues are generational. Just to give you an example, I spent a decade in the refugee camp, a decade being stateless, whereas my parents, they spent over 30 years, 3 decades being a refugee, being stateless, and then after coming to this country, they still face issues that are lingering on, issues of statelessness. And then you go even further back to another generation, my grandparents, my grandma, who has spent her entire life, and we're talking about over 10 decades, over 100 years. She's quite lucky enough to have lived that long, but her 10 decades, her entire life, she has never had a place to call home. She spent her time in Burma, where she was expelled, where she was segregated, where she was where she wasn't treated as human, where her condition, her emotions, herself, it was all dehumanized. And then she moved to she fled to the refugee camps, and for another 3 decades, the same issues lingered on. So these, my people, I'll speak in terms of my people, because this is something I have firsthand experience with. My people have had these issues for decades and for generations. So the issue of statelessness isn't just limited to us or to a certain years, and especially if you count children in these senses. These are people, the next generation, who are still going to be affected by the issues of statelessness and what it means to be statelessness. What it means to be stateless, like I mentioned before, is, to put it in its most simplest form, is to be dehumanized. Your dignities, your basic dignities in life, taken away from you, and it's not a nice feeling, of course, because you start wondering why this happens, and you start wondering why people treat you like that, and then it makes people lose faith in humanity. And this issue, or this report is a good way, or a good step in the right direction, because what it does is it makes sure these people and their experiences do not get overlooked. And so what we need in terms of a community, what we need in terms of people who have been stateless, is just these issues to be amplified. And the first step to doing this is reading this report and taking on its recommendation, like Nina mentioned. Improve access to quality and legal advice on citizenship is fundamental. It's needed, because this is something that my people have suffered when they first came to this country. A lot of people have lost out on fees, especially for children. An example would be me and my siblings. We lost out on a lot of money because we didn't understand the legal ramification. We didn't understand the situation of stateless people in the UK, and this is money we never got back. And what usually happens is that these children, they have to wait a certain period of time, and then they miss out on the time frame. So I think it's my time now, but like Andie's mentioned, if you have any question in terms of the British Rohingya community in the UK, or in terms of stateless people in general, I'm more than happy to answer.
Sirazul, thank you so much. That was a very sort of obviously very personal and brilliantly passionate presentation. And I think, it really helps, as you said, to remember the reality of actually living as a stateless person, but as a stateless child in particular. And, we really appreciate you taking the time to speak to us today about your sort of families and communities experience. So thank you so much. We will send any questions on to you in due course, and thank you for joining us. I'm now going to move on to our next speaker, who is Andie Sirel. So Andie is a co-founding partner and legal director at Just Right Scotland. He leads Just Right Scotland's Scottish Refugee and Migrant Centre. He's a specialist working with migrant children, including asylum-seeking children, trafficked children, and children in care. So welcome, Andie. Thank you for joining us, and the floor is yours.
Thank you very much, Andie. I appreciate that. And thank you, everybody, for inviting me along. I'm following an excellent presentation from Sirazul there, and it was amazing. Thank you very much for telling us about your own personal experiences. I'm just going to quickly share my screen. If you just bear with me a second. There we go. Hopefully everybody can see this. So thanks very much for inviting me along. I would like to say that we very much welcome the report that ENS have produced. It's a comprehensive insight into a complex and under-discussed area of UK law. And we were very, very happy to provide any form of evidence base to contribute towards the findings and recommendations in the report. Now, I've been asked to speak on the experiences of children and young people that I've worked with who are stateless or at risk of stateless, as well as challenges to resolution for them, key recommendations from a practitioner's perspective, and a note on the Borders Bill, all within 6 minutes. So I'm going to try my very best to motor ahead here. When we're talking about experiences of stateless and at-risk children, I completely defer to Sirazul's presentation. He very eloquently described the human reality of what it feels like. My limited insight into this comes from a legal practitioner's perspective, and I think it's not possible to talk about that without making a quick reference to the hostile environment. Many stateless children experience the full effects of the hostile environment because they're either undocumented or have precarious status. It's very unusual for us to receive a referral from somebody who says, I am stateless, please help me resolve my situation. That referral is triggered by one of the elements of the hostile environment that envelope the families that we're talking about here. So, access to education, whether it's, wanting to go to college or university after school. Maybe there's a housing and destitution issue. Maybe somebody's applying, there's a school trip up and they want to go and go on the school trip and they cannot travel. These issues are the things that often raise the legal issue from the outset. And then we face significant challenges in attempting to resolve this. First of all, you would talk about understanding and knowledge. Now there are stateless families who know very well that they're stateless, and Sirazul's examples there definitely speak to that. But there are also families and children and young people in particular who are not aware that they are stateless or indeed at risk of statelessness. And finding out, getting that information is a key part of it. Children in care are particularly at risk, with local authority workers unable or lacking in an understanding to provide this to the families and the children and to help them resolve. So things that you hear, I'm not an immigration officer, I feel like I'm racially profiling. These are understandable sentiments to have, but they contribute to a lack of awareness and they contribute a barrier to resolving the situation. Understanding of British nationality law, believing birthright citizenship still exists. Not really understanding what immigration status is. Very common, it's you're an asylum seeker or you're not, and that's it. So there's a deficit in understanding there, and not thinking immigration issues apply to children at all. These are common things that we see. And all of this results in delay, which is critical to resolving their status. It is very detrimental. Other challenges are state structural barriers to resolving status. Once awareness is there and there's an understanding of how to resolve, actually doing it is very, very hard. The law is unbelievably complex. Since 2010, the immigration rules have more than doubled in length. They are labyrinthine, very difficult to navigate. So the law is more complex. Families can't do citizenship applications or immigration applications themselves. They need a lawyer. Well, guess what? Legal aid in England and Wales was eradicated for immigration and nationality. So you have to pay for a lawyer. All the while, you are very often locked out of things like employment or access to benefits. Maybe you get yourself an access to a lawyer, then you need to pay for the application. Application fees for citizenship and nationality have gone up 331% since 2014. If you're in an immigration sphere, not nationality, in an immigration sphere, you have things like immigration health surcharges, gone up 300% in the last few years. These are state barriers. It doesn't need to be this way. So as a result, reading the report, the key recommendations from my perspective are strengthening legal safeguards in British nationality law to prevent statelessness, removing practical barriers that are there to acquire citizenship, and improving access to free, quality legal advice and information. And the last note I'll just quickly say is on the Borders Bill. It's a big thumbs down from me. Clause 9 is evidence-free. The stats don't back up the abuse claims. 10 applications in 2015 as opposed to 1,000 in 2020. This is the policy position. Well, that just tells me that it was very poorly, even more poorly understood in 2010. Statistically, even at its height, we're talking about tiny percentages of applications from stateless persons, citizenship applications from stateless persons. It's just not made out. And the clause is filled with vagueness, and fundamentally, it's unnecessary. This is going to increase statelessness, not decrease it. And that is where I'll finish up and pass back to Andie. Thank you.
Andie, thanks so much. That was so, useful and insightful. And I think, as Sirazul presented the realities of living with it, you very clearly presented the realities of then trying to resolve it from a legal practitioner's perspective, and some of the challenges that you face, let alone the people who manage to reach out to you, and let alone the people who don't even have that ability to access folk like you. So thank you for the work that you guys are doing. And we will now move on to our next speaker. I'd like to introduce Anita. Anita is the head of the Migrant Children's Project at Coram Children's Legal Centre, and she also co-chairs the Refugee and Migrant Children's Consortium, a group of 60+ organisations coordinating to influence government and promote these children's rights. CCLC runs a dedicated children's citizenship registration project as part of the Kids in Need of Defence UK partnership, and has a particular focus on resolving nationality for children in care and care leavers. So I'll hand over to Anita. Thank you.
Thank you very much. Thank you, everyone. Thank you for inviting me. Thank you for the report, the presentation of report, and the very powerful presentations that we've just heard. So as Andie said, I have a kind of limited insight into this issue, and really the way we see statelessness, and what I wanted to say something about is the way statelessness fits into the wider picture of children's nationality. So as Andie said, sometimes people come and say, I'm stateless, or my family is stateless. And as Nina mentioned, that's often people who belong to particular nationality groups. We do also see people who believe they're stateless when actually that's not the case, or they use the word. And I think that one of the important things about this report is to just better understand the word, because we very often see people who think that if a child doesn't have a document to say they can be in the UK, or if they don't have a passport, they use the word stateless. And I think what this report is important in doing is helping people understand that statelessness is something very specific. So the way we see statelessness in our work is that we have kind of large caseloads of people we represent and advise, and there's hundreds or thousands of those, and amongst those, statelessness will crop up, and we all need to get better at seeing where it does. And as Nina said, sometimes that's in places that perhaps people are less likely to expect. So we see our experience at CCLC well reflected in this report, and we welcome the report, as Andie did. We can attest to the difficulties, particularly for looked after children, getting access to their nationality. So we supported about over 350 children and care leavers to apply to the EU settlement scheme. And there we saw lots of children who were just having enormous difficulties, as Nina mentioned. So for example, a Romanian child who was taken into care shortly after birth. The mother refused to comply with requests to assist in getting a passport for that child. The father left the country, disengaged, was unable to be traced. And there was just no functional way to get a Romanian passport for that child, because the under Romanian law, both parents retain parental responsibility unless stripped by the Romanian courts. So functionally, this child wasn't able to show that they were Romanian. We made an application with this child under the EU settlement scheme without a document and supported the local authority to apply to register this child as British under a kind of wider discretion, not related to statelessness, a wider discretion, section 3.1 of the British Nationality Act 1981. And then in the care planning, the social services emphasised that this child was Romanian and that it would be easier once they became 18 to prove that this child was Romanian. But it just goes to show that example, the kind of difficulties of actually accessing nationality in practice. So for us, the key message of the report is really this sentence. When a child's nationality is unclear or undocumented and their nationality status remains unaddressed, there's a risk that they are or could become statelessness. And the reason why I think that's important is because it shows that it's really not about focusing on statelessness in isolation, but a focus on resolving nationality for every child. And one thing I would really underscore is that this has to be simple. Teachers, social workers, professionals, parents, they won't understand the intricacies of nationality law. We have to have this simple message, a passport for every child. We think that we support the recommendations in the report around birthright citizenship, though I think there's a kind of strategic discussion to be had about, in the current political climate, what we push for when. And personally, we think that the recommendation on the registration fee might be kind of strategically the one that other organisations are kind of getting behind in a collective way that we might put the emphasis on. We think that the report is completely right to say that there's a lot that needs to be done to show how statelessness impacts children and then to raise awareness about what needs to be done about it. So we have to make the argument. Sometimes Andie said about kind of social workers being unsure about what their role is and what they should do. We also see that sometimes they're unsure why nationality matters. What is it about? Is it just about a passport? Is it just about traveling? And making those arguments that, as Sirazul so powerfully said, this is foundational to children's identity. This is foundational to their rights. This will determine their future. This needs to be better understood. Also, just on a practical level, a passport is required. You could get around it with the EU settlement scheme, but a passport is required in order to make Home Office immigration applications. So addressing children's nationality really is a kind of foundational first step. So what can we do to make people more aware? This is touched on in the report. We think there are separate tasks, some of which Nina touched on. So firstly, we really support the recommendation in the clause in the report for making parents and families and the public generally just more aware of nationality law rights. So I know from my personal experience having children, lots of families just don't know whether their children are British or not, even if they're born in the UK. And we think that more could be done when children are registered, when parents register births, in public health communications that families get. More could be done so that all families understand better about nationality law rights. Secondly, non-legal professionals could understand better about nationality in general and why it matters so much. So some of this isn't about the technicalities, it's really just getting across that simple message, why this matters so much. Beyond training of individual social workers, there is quite a lot of work going on, particularly with local authorities, so partnership working to improve the approach. And one example that I would highlight is Greater Manchester Immigration Aid Unit working in Manchester with local authorities to have a kind of systematic tracking of nationality for every child in care and care leaver. And there are other projects around the country, including some in London. And then immigration lawyers having a better understanding of nationality generally, and then statelessness within that, more specialist nationality practitioners bringing, as Andie said, bringing nationality back into the scope. It's never been, bringing it into the scope of legal aid, and making the training schemes address statelessness better. So for example, when you accredit at OIC level 1, statelessness isn't really covered in an adequate way. in the resource book and in the kind of training materials. So I think that the report is really welcome. We support its recommendations. We think there's a kind of strategic discussion, and we'll come on to that with the bill, about which of the recommendations to push for when, but we thoroughly support what Nina and Andie have said about the dangers of the clause, and that it's just simply not going to work to try to force families to obtain a nationality that the Home Office thinks that they can acquire. Thank you very much.
Thanks, Anita. And halfway through that presentation, I started to think how clever I was, and then realized that you're actually talking about the other Andie. So just to acknowledge that most of what Anita was referencing was the great presentation from Andie, Sirel, and not myself, sadly. But now it is my turn to do a very brief presentation. So both Nina and I just want to slightly put all of this, the discussions and our report, into the sort of the parliamentary process that is ongoing at the moment. I'm not going to take up too much of your time. I just thought that it might be useful, especially for those of you who are unfamiliar with the parliamentary process, to briefly outline the steps that a bill goes through in Parliament, where we are with this Nationality and Borders Bill, and you know, sort of touch on where there are possibilities, opportunities for, you know, us all to get involved. So if you have a look at the slide that is now available, the sort of diagram along the top is a normal sort of bill process. Now, under sort of parliamentary rules, a bill can start in either house, but in this instance, it's actually started in the House of Commons. So it goes through the 5 stages in the House of Commons, then it will go through to the House of Lords, and then at the end of that, it will receive royal assent and then become law. So particularly for this bill, we've already passed through the first and second reading stages of the bill, and those took place earlier in this summer. And we're now heading into the committee stage at the House of Commons level. The committee stage is when a committee of MPs that are made up to sort of reflect the House and in terms of party sort of political divisions, meet together to scrutinise the contents of the bill. Crucially, at this stage, it's worth knowing that it's only the committee members themselves who can propose amendments at this stage. So the makeup of the committee is super important, and if you want to access anyone who's going to be on the committee, then those will be the people to be able to table or comment on amendments. So at the moment, they are scheduled to hear evidence from invited experts, including ENS at the moment, on the 21st and 23rd of September. And then they will hold somewhere between sort of 8 to 12 sessions, where they will propose and debate possible amendments and go through the bill line by line. And this is due to start on or around the 19th of October. And again, just a note to flag is that amendments, the deadline for submitting amendments is the 14th of October. So after that, there'll be no opportunity to include or influence amendments at that point. But then between the 14th and 19th and onwards, the committee will be discussing and looking at all the proposed amendments and the bill in its entirety. This, you know, kind of takes as long as it takes, but it usually takes about sort of 3 weeks, and as I say, around 8 to 12 sessions. After this, it's then the third reading stage, where any of the agreed amendments from the committee stage are then proposed to the House of Commons generally. If it then passes, it will proceed onto the House of Lords. And with this bill, we're expecting that to probably be around mid to late November. And then the whole process starts again, but within the House of Lords. The only real difference within the process is that during the committee stage in the House of Lords, it actually involves all members of the House of Lords as opposed to a selected number in the House of Commons. And any of the Lords can speak or table amendments. So again, just the same process happens. It goes through readings, committee stage, and then an agreement from the House of Lords where it returns, and any changes are then, any proposed amendments by the House of Lords are then sort of agreed or debated back in the House of Commons. Assuming everything is sort of agreed at that stage, it then passes on for royal assent and then eventually into law. So, you know, with a fair wind behind it, this could be in place as early as the new year. So anyway, just to give you that context, because I thought it would be, you know, useful to understand where we are and what steps are next. But then, and in part because Nina is going to just talk about some of our ENS's main concerns around the statelessness clause that amendment is being proposed at the moment. Over to you, Nina.
Thanks, Andie. That's a really helpful overview of the process. So I think maybe just to go back to basics. I mean, obviously the bill, you know, we're talking about part one of the bill and one particular clause. It's a big bill. There's an awful lot of stuff in there, and there's a lot of wider debate, rightly, on some very concerning aspects of part two of the bill around asylum and refugee rights. But just to zoom right in on the very specific clause that we're concerned about today is clause 9, stateless minors. And what the government is proposing to do is basically to amend that existing vital safeguard in British nationality law that basically puts into that operationalizes its international obligations to prevent childhood statelessness. So there's a specific provision in the British Nationality Act currently that implements this international obligation that the UK has to prevent and reduce statelessness. It's quite a simple clause, and you know, in our view, it's in line with international law, and in terms of the provision itself, it meets that international standard, and there's really, as others have said today, there's really no need to amend it, and there's no evidence of any need to amend it. So what the existing provision does is that it allows a child born stateless in the UK who's always been stateless, after 5 years of living in the UK as a stateless child born in the UK, that child can register as a British citizen. It's quite a simple provision, and that's what it does. And you know, we've shown in our report, and others today have spoken to some of the difficulties that children, stateless children or children at risk of statelessness, already face to resolving their nationality problems. So we just think it's very dangerous to try to restrict this provision in any way, which is what the government is trying to do with this proposal in the bill. So what, I don't want to go into too much technical detail, but what the proposal in the bill basically does is give so first of all, for children aged between 5 and 17, it kind of restricts children's ability, or potentially restricts children's ability to stateless children's ability to register as British. So what it does is it introduces some quite potentially far-reaching discretion on the part of the Secretary of State to be able to decide whether the child has acquired another nationality and is therefore not stateless. So we think this is very dangerous, potentially contravenes international law. So we have a lot of concern about it, and you know, for all the reasons we've already discussed, we just don't think the amendment is necessary. The Home Office didn't provide any evidence of any alleged abuse of the existing provision, and on the contrary, as we said before and others have said today, you know, our report shows how there are already problems for children accessing the existing provision, let alone if it's further amended to become more restrictive. So we've put forward in our report the rationale, we've put forward some good practice examples from other countries that have even more simple provisions in their nationality law to prevent childhood statelessness. So there's good practice out there that can be drawn on, but our overall message is there's no need to amend this provision, and clause 9 should be dropped from the bill in its entirety. And that's really what we would ask others with an interest in this issue who are doing lobbying or advocacy around the bill to call for, is just drop this provision. It's really not necessary. It risks leaving more children in the UK stateless, and it's not needed, and potentially it contravenes international law. So let's drop it, is our message.
Thanks, Nina. Yeah, I'm going to ask you to, that was really helpful, and I hope that's also helped further sort of embed sort of our concerns based on our research of this proposed amendment. I'm going to ask you to leave your camera on, and also ask all of our other speakers if they wouldn't mind turning their cameras back on, that being Andie and Anita. It's now the time for you guys who've listened to us for the last sort of 45 minutes to now have your opportunity to ask any questions of the panelists, or to, if you want to have any say, we can read out from the chat. I haven't seen any questions yet, so get typing if you have anything. But in the meantime, just to sort of say that, with the whole issue of immigration issues that are being discussed and everything, statelessness can often seem like quite a niche, and can often be sort of put to one side, as has been mentioned. Other immigration issues can often take precedent. So obviously it's really important for ENS and ourselves to keep raising this, because the real impacts on the people affected by it are quite serious. And it's been great. We've had over 60 participants, sort of folk listening to this webinar. So a useful sort of guide to the fact that this is actually of interest to people out there. And this is for ENS at least, this is the start of what we hope to do on childhood statelessness. Of course, there's been lots of other organisations who've been working on it, and we hope to continue working with them. In case nobody else has any questions, I do have a couple of questions. I just also, Andie, given that you're based in Scotland, I thought it could just also be quite interesting if you could very briefly sort of describe the differences with how statelessness is dealt with in Scotland compared to England and Wales. This bill, from my understanding, all except for a few clauses, will sort of apply across the whole of the United Kingdom. But of course, you do have your own sort of legal system. So I just wondered if you could sort of explain, and I think it's some of the stuff that you have up there could be good examples of good practice that we could use down here.
Sure. So the first thing I'd say is that everything we've spoken about today applies in Scotland. The UK immigration and nationality laws is UK wide. So we're stuck with that up here. There are some nuanced differences though. Legal aid is available in Scotland for this, always has been, and yeah, I can't say it always will be, but it's there, right? There's still those problems around like awareness, even amongst lawyers. Do lawyers work with this very often? Not really, to be honest with you. So there are still issues there, but legal aid is fundamentally available. Two sort of distinguishing things about Scotland, I would say. First of all, in terms of our devolved law, there are ways to mitigate the negative consequences of being stateless or at risk of stateless. So for example, the Scottish government have incorporated the UNCRC directly into the Scots law. Now, the UK government have challenged it, and it's in the Supreme Court right now about whether the Scottish government is allowed to do it. I won't say any more than that, and we're waiting for the judgment, but hopefully we're allowed to incorporate the CRC, and that will have an impact on the ground, right? So it'll allow people like me to litigate CRC rights in Scottish courts. And the second thing is that we have influence over what maybe not the legal definition of being a citizen, but what it means to be a new Scot, we call them up here. You know, just because you're not a citizen doesn't mean to say you're not part of our society. And so we run a project funded also by Paul Hamlin called Rethinking Citizenship. We have a lived experience group working alongside us in order to try and improve domestic laws, domestic policies. Again, this is about the hostile environment, the things that affect us on the ground, in order to try and make a more inclusive society, I think. You know, so extending the franchise, extending the right to work, these types of things, which have been successful. Not necessarily the right to work, but the franchise, for example, is a good example of a more inclusive idea of citizenship. Broadening out education, these types of things. So there are things that we do up here that are slightly different, I suppose, from that perspective.
Yeah, that's really interesting, and I guess we'll wait to see on the Supreme Court decision on the CRC integration. That would be great, obviously, if it goes through. We do have one question, so I'm going to put it all to the panel, but then also slightly target another question to Anita. But the question that's come through is from Katy, who asks, to what extent do you think the proposed changes to Schedule 2, Paragraph 3 are a response to the case of MK and the registration of children with Indian and Sri Lankan parents? So I'm going to put that to all of you guys, but also Anita, I was just wondering, particularly with obviously the children you work with, children in care, they are in a unique situation, and you said that you don't come across statelessness a lot. Do you think that's in part because, as you sort of said in your presentation, it's that the people who are working with the children in care are less aware of it, or are prioritizing sort of resolving other immigration status issues? Or is it that, it's just not something that you see in your particular work that often?
Do you want Nina to answer the question about MK India, or shall I just answer that question first?
If you do sort of just a quick 1 minute.
Yeah, just quickly. I think that it's not necessarily a question of awareness. And I suppose my experience really is grounded in having done lots of training for social workers. And I think that this can become very, very complicated. So really what I'm trying to get across is just a message that has to be simple, and that if you address nationality systematically, it will transpire that some children are stateless. But as Andie Sirel said, it's often not apparent at first sight that a child is stateless. So really what I want to get across is not that this is a kind of niche issue, it's fundamentally important, but the way to address it is to address nationality across the board systematically. And I think that I would say that the prevalence of statelessness, as the report highlights, it's just very, very difficult to estimate. But the way we'll get there in finding every case is to address nationality systematically.
Fantastic, thank you. That was very concise and excellent. Nina, you have about 30 seconds to answer Katy's question and say anything else. And Andie, I'm going to pass over you if that's all right.
I'm not sure if it's possible to answer that question in 30 seconds, but just to say I wholeheartedly agree with Anita, and simple message and ensuring every child's right to a nationality is realised, I think is really important. So Katy, thank you for your question. So it's hard to tell, but we suspect there's a link between MK and the proposal by the UK government to amend the safeguard. So Schedule 2, Paragraph 3 that Katy's referring to in the chat there is the provision that I was talking about to enable stateless children to register as British. And this is what Clause 9 of the bill is proposing to amend. So MK India, I think my colleague Patricia has just posted a link in the chat. So this was a case, a High Court judgment from 2017, which concerned a stateless child born in the UK to Indian parents who didn't register their child with the Indian authorities. And the court found that in order to register as a British citizen, the child was not required to have sought and failed to acquire the nationality of the parents. So the child could acquire British citizenship if the other requirements in the provision were met, as she was and always had been stateless. So that's what that judgment found. The implication in the UK government's stated rationale for the amendment, the Clause 9 amendment, is that there was an increase in applications to register as British by stateless children from 2017, and you know, there could be an implication there that that's the result of this judgment. However, it's really important to state, and our report states this, that stateless children, this is a bit complicated, so bear with me, stateless children applying to register at this time must have been at least 5 years old in 2017. So the provision is only available to children born in the UK who've always been stateless and lived in the UK for 5 years prior to the application. So any decision made by parents not to register their children, any hypothetical decision as nationals of another country, would likely have been made 5 years previously, around the time of the child's birth. So some parents might have learned about the possibility as a result of the MK judgment, if they're very on top of the law and judgments, or getting advice about this from solicitors, but their decision about whether to register their child would have been made prior to this, 5 years prior. So this, we don't think there's any link between the increase in applications to register between 2016 and 2019 and the MK judgment. So we just haven't seen any evidence for this. That was a bit technical, but thanks for the question, and I hope that's kind of clear. It's explained in more detail in our report, so you can find more information there.
Thanks, Nina. We have one other question that just got in under the wire, if anyone wants to sort of respond to it super quickly.
Just super quickly, I would say that Elizabeth's question, which says, will the children born in the UK to refugees with temporary status be at risk of statelessness? That's an excellent question. I think what we see with the degrading of the provision that Nina's talked about with Clause 9 is that we will still have other clauses in the British Nationality Act. So what we'll see is an increasing reliance on Section 1(4) if a child is born in the UK and live in the UK till the age of 10. And what I think we're worried about, what all this discussion of nationality law worries me, is might we see a crackdown on that provision? So rather than pushing for birthright citizenship, we probably are looking at protecting Section 1(4), I would say, strategically. And that comes down to the second question from Anivaldo, which is, yes, children's nationality registration can be the first step to a family regularising their status in the UK. And I think in the current political climate, if we raise that issue, we have even more potential arguments about it. We want to keep children's nationality law rights unpoliticised, basically, because for exactly that issue, if parents aren't documented, but they can regularise under the immigration rules on the basis of having a British child, potentially could create some arguments about children's nationality law rights. And I think Section 1(4) is our kind of fallback, children born in the UK, living in the UK to the age of 10. And we need to work on really defeating the provisions in this bill, but also protecting that provision.
Fantastic, Anita, that was just brilliant because you answered both of them very swiftly and succinctly, so thank you for that. Unfortunately, we do now have to wrap up this discussion. Just leaves me to thank all our panelists for taking the time out of their super hectic schedules to share the insights, your insights and expertise. You've, as always with these sorts of things, you've given us a lot of food for thought to take away and reflect on, and hopefully there will be some additional sort of work that we can all do together. Thank you to the over sort of 60 people who have joined us today and for your comments and questions. Please get in contact with us afterwards, individually or collectively. Or if you have any follow-up, we can pass on messages to Anita and Andie, and of course to Sirazul, who has had to leave us. We thank you also for joining, because this does show us that you are interested and committed to this issue. And of course, it's such an important issue and has such a lasting, as Sirazul put it, generational impact. We encourage you all to, all of those who haven't, which obviously I'm assuming most of you have, but we encourage you all to read our reports and also share it around your networks. Help us, work with us to figure out how we can ensure that stateless children in the UK are able to see a resolution to their statelessness that is as quick, easy, and as inexpensive as possible, because these are the hurdles that that just should not be there. With all that, I'd like to thank you all. I hope you have a good rest of your day, and thank you once again. Goodbye.